See? Acme, I don't see. There he is. Thank you, Peter.
You're welcome.
All right, I'm trying to gather in the folks that are on Baker versus Keelhorn. I know that you two are. Mr. Cortez is here. Let me get him in.
Good morning, Your Honor. Good morning, Randy. Good morning, Dan.
Good morning, everybody.
How you doing? Hey, Dan, how are you?
Okay,
Good, good.
Shannon, put us on the record.
Go ahead, Your Honor.
Okay, we are now on the record in Baker versus Keelhorn matter. Counsel, state your appearances, please.
Good morning, Your Honor. This is John Turk on behalf of the plaintiff, Anthony Baker.
Good morning, Your Honor. This is Daniel Cortez, appearing on behalf of Dr. Monfett, Henry Ford, and IEP.
And Your Honor, this is Randy Hackney on behalf of Dr. Gene Keelhorn and Columbia Medical Center.
And I know this is a defense motion up this morning, but I don't recall which of you filed it. So whoever filed, go ahead.
I'm pretty sure it was me, Randy.
Yes, it was, Dan. Go right ahead.
Just making sure. Good morning, Your
Okay,
Honor.
Doug, before I go any further, I just want to make sure that there isn't anyone else that you're expecting this morning. I don't see any other names that appear to be associated with this file.
No, I don't think we're expecting anybody else, guys, right?
That's correct.
Not that I'm aware of.
Okay, go ahead, Mr. Cortez.
Thank you, Your Honor. Yes, this is our motion to strike plaintiff's wage loss claims. As a little bit of background for the court, this is a medical malpractice case. Mr. Baker was first diagnosed with mitral valve regurgitation, a heart condition, back in 2005. Lived and worked with that condition for a period of about 12 years without issue. He saw Dr. Monfett, my client, an emergency medicine physician, one time in December of 2016. Dr. Monfett noted he had a heart murmur and sent him to his PCP to follow up. Never saw my client, Dr. Monfett, ever again. The records and evidence show that eventually Mr. Baker worked the rest of 2017 until late summer, when he went to U of M and eventually was diagnosed again with this mitral valve issue and eventually had heart surgery. Now, the allegation in this case is that my client, Dr. Monfett, failed to diagnose his condition 8 months earlier, even though, in fact, the condition was diagnosed back in 2005. In answers to discovery, Mr. Baker has alleged lost wage damages in excess of $2.25 million. Mr. Baker, until recently, was a banker at Huntington Bank in the Jackson area, and he had been with that entity for a number of years. He's alleged that he's lost annual income totaling up to $750,000 going forward as a result of this alleged negligence. And then additionally lost potential future income based on a potential, maybe speculative promotion of another $1.5 million over a period of future years. We learned more of this at Mr. Baker's deposition about a year ago. We followed up with interrogatories because he mentioned that his estimates were predicated upon the fact that, as a result, his theory, that he could not complete certain banking transactions in the years after his heart surgery, and that led to him having decreased bonuses and the decreased likelihood of obtaining this promotion to regional president status. That is his theory. So we followed up on that testimony with interrogatories asking Mr. Baker to point us to these transactions that he was unable to close, to point us to these clients he was unable to obtain, and to point us to any evidence that showed that he was in any way likely or expected or maybe going to get this promotion to regional president status and therefore a higher income level. And we attached his responses to our motion. It's Exhibit G to our motion. Mr. Baker simply said he just doesn't have that information, and nobody's ever going to have that information. And that's the end of it. Well, beyond what he said, we've looked at his performance reviews from his employer. There's no evidence in there that he's not getting promotions or not getting bonus money because of any hard issues that he says are preventing him from working full 8-hour days.
So
We've deposed two.
Mr. Cortez,
Yes.
after I practiced employment law for over 30 years, I would be shocked if I ever saw any mention in a personnel file that someone failed to get a promotion because of a health condition.
Understood, Your Honor. Well, I think in addition to that is the fact that Mr. Baker continued to score similarly after his heart surgery as far as his overall performance scores to what he did prior to the heart surgery that he is talking about in this case. So the records indicate that his performance remained more or less the same, continued to meet and or exceed expectations of his performance. We've deposed two of his bosses, Mr. Frauenheim and Mr. Sheehan, who testified that Mr. Baker was not losing any income, bonus, or promotion potential as a result of his performance over the years after the heart surgery took place in 2017. And I think even more than that, we've learned that there's no direct correlation, at least within Huntington Bank, per the testimony of Mr. Sheehan, between straight up economic performance of the employees such as Mr. Baker and bonus compensation. We've also learned from that testimony that there was no discussion that Mr. Baker obtaining this regional president promotion that he says might have occurred sometime in the future at some unknown date. Having said all this, I know the court's familiar with the case law. That damages have to be proven in these cases with reasonable certainty. Reasonable basis has to exist for this computation. Before we even get to that point, the NSYNC case is very clear that the plaintiff needs to meet his burden to show that he's actually suffered this damage, that as a result of this alleged negligence, he's actually been harmed in the ways that he says he's alleging. Based upon the evidence we have in this case, all Mr. Baker can point to are his subjective beliefs that he's lost out on bonus income. We specifically asked him in writing to tell us what deals he was unable to close because he could not work more hours per day after this heart surgery. And he hasn't pointed us to any in 2018, 2019, or 2020. None. He can't point us to any. Secondarily, the only testimony in this case about whether Mr. Baker was going to maybe obtain regional president status in the future is from his bosses saying there was no discussion of that. So Mr. Baker hasn't shown any evidence that that was going to happen. So he has no proof that he was missing out on an opportunity for promotion as a result of this alleged negligence. He has no evidence that he was demoted in any way due to his alleged heart issues. And there's no proof that Mr. Baker's pointed to that he's lost out on any additional potential bonus money as a result of his heart issues. And that's really, again, I direct the court to the NSYNC case in particular, 262 MISH 518, that they have to be showing this injury in the first place, and then from there showing a rational basis to compute these damages. Remote, contingent, speculative damages are not considered appropriate. And that's really at the bottom what Mr. Baker is asking the court to allow him to talk about in front of a jury, is to say, yeah, I might have closed more deals. Which deals? I don't know. I can't tell you what client I was about to close a deal on. I might have gotten regional president status one day. Well, when, where, how, with who, who's going to promote you? Well, I don't know. Just take my word for it. I think the law is clear that such speculative damages should not be even presented to a jury. And for that basis, Your Honor, we'd ask that the court strike these lost wage damages.
So, Mr. Cortez, if Mr. Baker, prior to the health condition, worked 8-hour days And after the health condition worked, yeah, I don't know what it was. I don't remember. I'm sure you probably mentioned it. Let's say it was 5-hour days. Doesn't it make sense if his job is to close deals that you can't close as many deals in 5 hours as you would have closed in 8 hours?
I think that would be maybe potentially true, Your Honor, with respect to a job where somebody is making widgets, where it's a repetitive job that requires somebody to be sitting in a chair. But the testimony from Mr. Baker is this is not a traditional 9 to 5 job in the sense that the more he sits in a chair, the more bank deals he's going to close. The testimony was that it's more about having these meetings with clients. It's not really about, well, if I sit there for 8 hours as opposed to 5, I'm definitely going to have more meetings with clients. It's more about going to functions, which that's nothing that Mr. Baker can't do now as he could before he had this heart issue. Again, I think that there's an inherentness about this type of job that makes it in particular difficult to prognosticate the future. And we've asked Mr. Baker to do so based upon his experience in this field, and even he is unable to do so. As to, I think the question was specifically asked at the deposition. He used the term a bogey, a deal to be closed with a potential bank client. And we tried to get him to say, well, how many was it before and how many is it after that? And he can't give us that number. He can't give us a basis, Your Honor, to even be computing what is ultimately how many deals I could have closed before and how many deals I can close after. So at that point, the court, a jury, all of us, or even Mr. Baker apparently, are grasping at straws to understand what is the impact on a decreased number of hours, to your question, of 8 hours, how many clients can you close, versus 5 hours, how many clients can you close? We just don't have any basis to compute that after talking to Mr. Baker, his bosses, and looking at his job performance reviews.
Okay, thank you. Mr. Hackney, you have anything to add?
Just briefly, Your Honor, I would adopt everything that counsel, that Mr. Cortez indicated. And I think the court has correctly identified that in situations like this, it may be difficult to quantify, but it still is plaintiff's burden to quantify those things. And the law in Michigan, as Mr. Cortez has stated, does not allow for recovery for hopes and dreams. There has to be some substantial basis for that. We have not, despite repeated requests, been given any substantial basis by which a jury could do anything other than speculate on what those damages may have been. And that is my position relative to the motion. I don't believe that the plaintiff has put forth what they need to put, and I think the motion should be granted.
Okay, Mr. Turk.
Judge, this would be a terribly easy argument if Mr. Baker punched a clock and earned a particular dollar figure wage, and I could show that he missed 3 months of work and therefore that totals X dollars. But that's not real world for many people, including Tony Baker. And that doesn't make him, as a victim of medical malpractice, which I know substantively is not at issue in this motion, but must be accepted as true for purposes of the motion, does not make him less able to recover for damages that proximately have been caused as a result of the malpractice. I quite agree with Mr. Hackney and Mr. Cortez that there has to be basis on which a jury can reasonably find damages in this case. There are two bases that I would point out that I quoted and cited in my papers, but which provide that basis. Number one, there's the testimony of Mr. Sheehan, Tony Baker's supervisor, who said, even though he can't tell us a precise dollar amount, it is fair to say that Tony's compensation for 2018 was negatively affected by his failure to meet his production expectations and goals. That's Sheehan's testimony at pages 60 and 61. Second, you have Tony's, Mr. Baker's, testimony about his income, total compensation packages in 2017 and 2018, and before he realized he was going to lose his job because he couldn't continue doing it for 2019. A reasonable jury can say, if Mr. Baker missed 3 months out of the office or missed a substantial portion of the year and otherwise was hobbled because he wasn't able to put in the full hours that he normally would have and did regularly for many years before this, lose income. They might very well say, well, if he was not in the office 25% as much, maybe a fair way of attributing it is to say 25% of what he had been earning historically is a fair number to tag for 2020, 2021, or forever how long they reasonably anticipate and expect that Mr. Baker would have continued working in that position. It is
So let me stop you. I'm assuming he was a salaried employee,
he was.
even though he wasn't able to close as many deals as you allege. Was his salary reduced?
No, not that I know of. His base salary was $150,000 according to answers to interrogatories. Well, Judge, I should say, I suppose his salary has been reduced because he's been terminated from his job, but that was only recently. Up until his termination, I do not think his base compensation package was reduced.
And are we able, I mean, is there data available to show, I mean, Huntington Bank's a large organization. Is there sort of like a career path for somebody in a comparable position that you can compare with? Was he on that career path? Was he making progress and then all of a sudden stop making progress? I mean, do we have anything like that?
Yes to all of that. I will tell you there's nothing in this record beyond Mr. Baker's testimony that that's the case. There is a peer of his, Michael Debris, who is reticent to get involved because of his fears about job retaliation. But I'll be open with you, that's not part of this record. I think it is there and I would like to present it at trial, but I don't have it before you today. And so, I'm sorry, Judge, I didn't mean to cut you off if you had other questions.
No, you answer my question.
Thank you. And so that meets Mr. Cortez's argument that the NSING requirements have not been met. Those are substantial bases on which a reasonable jury, accepting this evidence is true, could find that Mr. Baker has suffered a significant wage loss. The other piece of law I think that's just critical for any just result in this motion to be achieved is that any uncertainty about causation must be resolved in favor of the victim. That's the thrust of the case law, Richmond versus City of Berkeley I cited, and some other law in the briefs I've filed. And it is supportive of the first point I made, which is that merely because Mr. Baker worked in a field which isn't as readily as or amenable to easy calculation of damages as a worker at McDonald's who's working by the hour would be, doesn't mean that he has to go without. I am not shying away from his proofs at trial or the burden of those proofs at trial, but merely because he can't say, I would have been promoted in 5 years, or show with certainty or a reasonable degree of certainty that he would have been promoted in 5 years or any period of time, doesn't make that an unavailable claim of damage. That goes to weight, but not admissibility. The jury is entirely free to conclude, as I'm sure Mr. Hackney and Mr. Cortez will ably argue, it is too speculative. Who knows what would have happened with Mr. Baker in the future? They are entitled to make those arguments, but at least as to that lost promotion claim, that's not amenable to disposition on a motion at this point. I would propose instead, even after recognizing that there are those three components of damages, he's been terminated now and has lost that entirely. And so that actually has gotten easier to prove. The lost bonuses and the lost promotion, I think the best way to pursue it is simply by proceeding question and answer at trial. And then if Mr. Hackney and Mr. Cortez, or both of them, wish to bring a motion for directed verdict at the close of proofs, they can do that. And maybe there will be something different, something lacking in plaintiff's claims that would make directed verdict appropriate. But at this stage, I would respectfully suggest that denial or dismissal of those claims would be like throwing the baby out with the bathwater, and the court ought not do that.
Thank you. Any further response, Mr. Cortez or Mr. Hackney?
Just briefly, Your Honor, I think you've hit on the fact that there is no base pay loss. So really, we're talking about two things, the bonus thing, which there's just nothing there. If Mr. Turk or Mr. Baker wanted to show us, they could have showed us a track record of prior volume of deals and therefore volume of bonus and trended out, or talk about the deals Mr. Baker was close to getting but didn't get in 18, 19, 20. If they had that evidence, They could have shown it to us. They could have shown it to the court. We could have it. We don't have that because it doesn't exist. And then secondarily, on the job track front, it's really Mr. Baker's hope and dream. Like Mr. Hackney said, that's not what we're here for. We don't award damages on hopes and dreams. And in fact, we have definitive testimony evidence from his boss, Mr. Sheehan, saying he was not being considered for that. So we actually, it's his word against nothing else. So for that reason, I still think that this is not appropriate to be in front of a jury, and the motion should be granted in its entirety.
Mr. Hackney, anything further?
The only other item I would interject, Your Honor, is that I think if we allow these types of speculative damages to be considered, we're inviting a future motion similar to a Daubert motion on any economic expert who might testify on behalf of the plaintiffs, who would then base part or all or part of their opinion on this speculative belief that Mr. Baker may have had, whether it be appropriate or not. We just start, going down a rabbit hole that plaintiff, in my opinion, simply has not offered the proofs necessary under Michigan law.
All right. Thank you, gentlemen. Well, even before Mr. Turk mentioned it in his closing words, my very thought was this, I believe, is a motion that's better brought at the close of proofs. If you want to make a motion for a directed verdict, once I've had a chance to hear all the proofs, if I think they're too speculative at that point, based on the evidence presented, I'll take that away from the jury. But I think at this point, this is something that is better left to a jury. So I'm going to deny the motion. I see you gentlemen are going to be back here next week for a dispositive motion.
That's true, Your Honor.
Well, that's what we wanted to ask you about, though, because the my office informed me that your office said we need to talk about scheduling, because I think we have a February 1st trial date and some other motions. And so I just wanted to bring it up after we completed this motion to find out what the court is looking at relative to scheduling. We do have a motion that is set for, I think it's next Wednesday, if I'm not mistaken, relative to, some motions for summary disposition. But we also have this February 1st trial date, at least it's on my calendar that way. So I was just looking for the court's guidance on exactly what's going on in your courtroom, because we're getting different kind of directives from courtrooms all over the state as to what should or should not be done in the interim during this hopefully final phase of lockdown.
I can tell you pretty confidently there's not going to be a trial in February. They're telling us here, don't anticipate doing any jury trials sooner than April. And once we finally open the courthouse to resuming jury trials, the criminal cases are going to get priority. I also have an abuse and neglect docket. Those cases are going to get priority. Civil trials, unfortunately, are going to be at the end of the priority list. So if we can't even start doing jury trials until April, when we can possibly start doing civil trials, I can't really predict very well. I can only predict that you can safely, assume that the February date is unrealistic. What I've been doing, we've had a number of cases that have been on the calendar, but my direction to my staff has been, don't even bother rescheduling a jury trial, reschedule a pretrial at a time when we hopefully have a better view of the landscape of what lies ahead, and we'll figure out when to schedule the jury trials then. Otherwise, they're constantly plugging stuff in and pulling it out, and I'm dealing with motions to adjourn or stipulations to adjourn. I don't want to put you guys to extra work. I don't want to put my staff to extra work. So what my plan would be to schedule a pretrial probably sometime in April. And then hopefully I have a better idea of where we are. I mean, assuming I don't dispose of this case in a week. I haven't read your briefs yet, so I don't know. I wouldn't say anyway, even if I had an inkling.
Well, that's actually what you've just stated is exactly what Judge Massaroni told us 2 days ago on another case, that the backlog is such that he's not looking until April. And then, the same situation, although I don't think he has the use and neglect docket that you do. He's down in Macomb County. But no, there's no problem with us going forward with motions, dispositive motions, things like that in the interim. At least according to your docket. Is that fair to assume?
All right. My motion docket, my non-jury trials and evidentiary hearings are all proceeding via Zoom. And that seems to be working well and moving things along. It's just the jury trials that I can't get to.
Okay, well, and one of the reasons I asked so early is that we need to notify our experts that they can take that February time off of their calendar to free it up, because I don't want to incur any cancellation charges, stuff like that. I know Mr. Turk is in the same ballpark, so I appreciate that information, Your Honor.
So we're on the docket for next Wednesday on the causation motion, guys?
Yes, I still have it on my mind for 3 o'clock next Wednesday.
Okay. Okay.
Yeah, it's I checked, and it's scheduled for 3 p.m. on the 16th.
Okay.
Yes. Great.
Okay, we'll see you back here then, gentlemen. Have a good day.
Thanks.
Thank
Thank you very
You
much, Your Honor.
too.
Appreciate it. Take care, guys.
Be well.
Thank you.
Okay, I can't. This thing says Brendan Beer as of record. Let's see, Basil Simon, I believe, is on the LaFleur Forge matter. Yes. Let's see, Stephen Stella, there he is. And Mr. Beer is not here. That doesn't surprise me. Okay, it looks like we have audio connections. This is the matter of the LaFleur Forge and Machine Company. Are we expecting anyone else to appear this morning, Mr. Stella?
Your Honor, I believe the attorney for the PBGC is supposed to appear. Mr. Simon, my client, is appearing.
Who is that attorney for the whatever you said?
John Ginsburg. Ginsburg.
I don't see anyone. You know what firm he's with?
He's from Washington, D.C. with the Pension Board Guarantee Company. He said he may be joining this hearing. He has really no opposition. He just wanted to observe.
He's not logged in by that name. I do have a couple of iPhones and a couple abbreviations. I can't tell what those are. I guess I can go through each of them and ask. He hasn't filed an opposition. He hasn't filed an appearance, has he?
No, Your Honor, no one has filed. No, I'm not sure whether he's filed an appearance, but no one has filed an opposition. That's for sure.
All right, I'm gonna guess someone of that stature, if he logged in, would have his name associated with the login, so I'm gonna assume that he's not present.
Yes, Your Honor. Mr. Abbott had indicated that he's not going to appear, but there is a representative. I believe it's Mr. LaFleur. Is it Mr. LaFleur, Basil?
Yes.
Who is going to?
I saw a LaFleur logged in earlier, but he has disappeared.
Okay.
Oh, wait a minute. Let me see. Here, I see. This is probably him.
Yeah.
Yeah.
That's probably him.
Yeah, that's him.
And it looks like we're having a little trouble with that audio, but I just allowed someone in with the identification of PLEFF. Could you identify yourself for the record, please?
That's me. I'm Peter LaFleur.
Okay, thank you. So Shannon, we've got Stephen Stella on behalf of the receiver, and we have the receiver, Mr. Basil Simon, also present. So Mr. Stella, I need to ask you, are you related to Dan Stella?
Dan was my oldest brother, and up until he passed away, the best looking, smartest, and oldest of all the Stellas.
I remember him from my very, very early days. I got my start at Dykema, and I remember him. I remember him as being quite colorful.
He did like his Jaguars and his beaver coats.
Beaver coats, and as I recall, a long cigarette holder.
Yeah. Yeah, he did the aqua pick, I think.
When did he pass away?
He passed away in '94.
I knew it was a while back, but I couldn't make the connection.
Yeah,
Okay. This is a motion for approval of the final report, final compensation costs of the receiver and of the professionals. There's been no opposition to this motion. I'm going to grant it. Did you submit a proposed order with the motion?
I'm checking that right now. My secretary and I have been working remote, so she mailed me the timestamped copy of the motion. So I'm just going to double check that right now.
And I will flip through the stack I have in front of me. Again, I didn't see it when I looked a moment ago.
No, Your Honor, I don't think we did submit the order. We have one. I know we have one prepared. We can get it over to the court. Just let me know how you want to do that.
You can actually email that to my law clerk.
Okay.
No, I've got your email address written down here somewhere, Peter. Why don't you just speak? Oh, here it is. His name is Peter Veldkamp. So it's PV as in Victor, ELD, KAMP at mijackson.org.
All right, so it's PVELD as a dog, KAMP at Michigan or mijackson.org.
That's it.
Thank you, Your Honor. And when we submit the order and the court enters it, will it mail it back to me, or how will I get a true copy of it?
It'll be mailed out.
Okay. That's great.
Okay, thank you, gentlemen. Have a good day.
Thank you, Judge. Thank you.
All right, bye
You're
now.
welcome. Okay, now let's see what else we got here. Walker versus Walker. So, Mr. Cohen.
Audio.
Booker Walker, let me bring him in. Okay, Mr. Conant, this is the matter of Walker versus Walker. I've got Mr. Booker Walker, the defendant, in the courtroom. Mr. Walker, can you hear me? Mr. Walker, I don't know if you can hear me, but we cannot hear you. You might want to check the audio settings on your device. For me, it's in the lower left-hand corner of the screen. Mr. Conan, are you expecting anyone else? I've got a couple iPhones logged in.
Yes, I was expecting probably Curtis Walker and Deborah Walker, the named plaintiffs.
All right, I'm going to let both of these iPhones in to see who they are. All the other names I recognize as being on another case.
Looks like someone's connecting right now.
Yeah, we've got a connection. What's your name, sir?
Curtis Walker.
Okay, hold on a minute. I'm going to put that name here. Okay, and ma'am, what is your name?
Deborah Walker.
Okay. All right, and I've got a login from Booker Walker, but apparently he's having trouble with his connection. I don't know if he can hear me, but I certainly cannot hear him.
Okay.
It looks like Booker Walker's calling me right now, Judge. Hello, Booker. Well, let me give your telephone number to the judge, because you could see your number online, but we couldn't hear from you. Okay, 745-9596. All right, hold on. Well, they tried to unmute you, but we couldn't hear you. So hold on. I'm going to hang up and let the judge know your number. Okay. So I'll hold up. I'm going to hang up on you. Well, just keep your line free. Hold on. All right. So I hung up on Booker. I've got his number, Your Honor, if you'd like that.
I wrote it down. I'll dial it now.
Hello?
Is this Mr. Booker Walker?
Yes, it is.
All right, we saw your login. This is Judge LaFlamme. We saw your login, but I don't know if you could hear us over that.
No, I can't hear or see anything. See or hear.
Oh, okay. For whatever reason, it's possible there's some settings on your device that need to be changed, but as long as we can hear you okay over the telephone, that's good enough for me.
Okay, all right.
Okay, Mr. Dennis Conant, on behalf of the plaintiffs, both plaintiffs are present. Deborah Walker and Curtis Walker, and the defendant, Booker Walker, is present. Go ahead, Mr. Conant.
Your Honor, I wanted to take default proof testimony. I think I can probably take that from Curtis Walker.
Okay, Mr. Curtis Walker, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
Curtis Walker.
You can put your hand down now. Go ahead, Mr. Koenig.
Thank you, Your Honor. Mr. Walker, you pursuant to the attached exhibit number 1 to the complaint are a co-owner of property commonly known as 2014 Merriman Street in the city of Jackson, Michigan. Is that correct?
That's correct.
And you own that property as joint tenants with full rights of survivorship with your sister Deborah Walker and with Booker Walker, the defendant. Is that correct?
That's right.
And as tenants in common, you each have an equal ownership interest in that property. Is that correct?
That's correct.
And there have been necessary repairs that have needed to be made to the property. Is that correct?
That's correct.
There was a hole in the roof that had to be corrected, and there was personal property that needed to be cleaned out of the property. Is that right?
That's correct.
And you also needed access to the property as a co-owner, you and your sister Deborah. Is that right?
That's right.
And let's start with access to the property. Have you been able to obtain access to the property?
No, we haven't. My brother Booker Jr. has denied us that by placing a lock that he has the key to it, only him.
Okay. And you've engaged my services to attempt to gain access to the property. Is that right?
That's right.
And you're aware of letters and communications I've made to the defendant Booker Walker to obtain access to the property. Is that right?
That's correct. I'm aware of you made several attempts. Many.
And you are aware that he has refused to make the property available.
That's
aware
correct.
of that?
That's correct.
And we attempted to have a realtor, Dan Verlin of Production Realty, go and look over the property to give an assessment of its condition. Did we not?
Yes, sir. That's correct.
And is it your understanding that Mr. Verlin was not able to get into the building to access the property because Mr. Booker Walker, the defendant, would not cooperate?
That's correct.
Okay. And as part of the attachments to the complaint, exhibit number 2 shows that that $1,600 was paid for a clean out of all of the property that was in the premises and on the as well as outside the premises. Is that correct?
That's correct.
And you paid your equivalent share of that money, did you?
Yes, sir.
And to the best of your knowledge, Deborah, who's standing by, also paid her share.
Yes, she did.
And is it your understanding that in fact there's property left in the premises that was not removed, even though you paid to have it removed?
That's correct. We spoke to the vendor who did the move, and he told my sister and myself that Booker Jr. would not allow him to clean out the premises, the property.
Okay. And you actually paid to have it all cleaned out, is that right?
That's correct.
Okay. And the roof repair is attached as exhibit number 3, and that cost $8,795. Is that correct?
That's correct.
And that was necessary to keep water from coming into the premises?
Yes, that's correct.
And did Mr. Booker Walker pay any portion of that money?
Not a dime, not a dollar.
So how was the $8,795 paid? Did you?
It was paid by myself. Matter of fact, I covered the entire cost myself.
Okay. On behalf of yourself and Deborah?
Correct. That's right, sir.
Okay. And have you asked Mr. Walker to contribute toward the cost of the repair?
Yes, we have. Through you, we have made several offers and no responses yet.
On July 20th, there's attached as exhibit number 4, a letter authored by myself that you authorized that advised him of the expenses that had been incurred on the property and the fact that you've been denied access. Is that correct?
That's correct.
and you asked him to cooperate, or else legal action would be taken. Is that
That's
correct?
correct. That's correct.
Okay. So you've had to take legal action because you still have been denied access to the property. Is that right?
That's correct.
Even though you are an equal co-owner of the property.
That's
Is it,
correct.
Now your complaint says that you want Mr. Booker Walker, the plaintiff, to first of all, provide access to the property, to make sure that it's cleaned out and to reimburse you for expenses you've incurred. And you now ask for $3,000 in attorney fees that you've had to incur to get his attention and ask him to cooperate. Is that right?
That's correct.
Okay. There's a proposed judgment that has been prepared that seeks this relief, and it asks that unless he pay up the funds that you've asked that are delinquent and due and owing, along with your costs, that if he doesn't do that within 30 days, that you have the right to go ahead and get the property listed and sold, take your money back that you're out, and then equally divide the proceeds. Is that what you desire to do?
Yes, sir. That is our desire.
Okay. Your Honor, I don't have any further questions of Mr. Walker. I'll leave the court to if they have any questions that need to be answered.
Okay, I do have a few questions, Mr. Walker. I'm looking at the quit claim deed. Well, I was looking at it. Hold on a second. Where'd it
The
go?
exhibit number 1, Your Honor, to the complaint.
All right. So what was your relationship to Norma Walker?
She was my mother.
And she quit claimed this property to a number of people, including Henry L. Walker.
Yes,
who
he's
is
my
Henry?
deceased brother.
Okay. To yourself, Curtis
Correct.
Walker, to Deborah Walker, and to Booker T. Walker Jr.
Correct.
Okay. And is there anyone currently residing in the house?
Not to my knowledge, it is. There's no one there.
Do you know the last time the house was occupied by anyone?
I do not. When my brother passed away in July of last year, I believe the house has not been occupied by anyone.
So your brother Henry was living there?
Correct, until his passing in July 1st, I believe, of last year.
I see. And when did your mother pass away?
She passed away in August of 2010.
And Henry had been living there with her at the time she passed away and then continued to live there afterwards?
That's correct.
Okay. Do you have any idea what the value of this property is?
I do not. That's one of the reasons why we wanted to get an appraiser, to evaluate the value of the home, the property.
Mr. Conan, do you happen to know what the SCV is for this property? Do you have that?
I probably do, Your Honor. That's one reason why, of course, we tried to get Mr. Verlin out to here. I find it, Your Honor. As of 2019, the SEV was 18,000, so that would have put it at $36,000.
All right, thank you.
That's the most recent I have. I haven't updated it.
All right, those are the only questions I had for you, Mr. Walker. I mean, Mr. Conant, are you essentially asking for partition of the property? And obviously, since it can't be individually divided, that it just simply be sold and the respective parties compensated for their interest minus the costs that are involved here today?
Well, I don't know that partition is available to me, Your Honor, because it's held as joint tenants with rights to survivorship. But I am asking that these expenses be equally shared by Mr. Booker Walker. And if he doesn't pay up the attorney fees and the expenses that have been incurred for us to gain our legitimate access to the property, within 30 days of the entry of the judgment, I'd like the judgment recorded at the Register of Deeds office with the ability to go ahead and sell the property and get our expenses back and then equally divide the proceeds between the three of them.
Any further proofs today, Mr. Conant?
I don't have any. I've got Deborah Walker standing by, but her testimony, it would be the same as Mr. Walker's, Curtis's, so I don't think I need to have her testify.
So, Ms. Walker, do you support your brother's request here that this relief be granted?
Yes, I do.
And obviously, Mr. Booker Walker, you are in default. That means you were served with a summons and complaint, and you failed to answer it within the time prescribed by statute. Is there anything you would like to say before I render my decision in this case?
Yes, I would. I did receive the summons to appear, but I had no idea how to do it under the circumstances of this shutdown that we had. I did not understand that you could go on through Zoom or anything like that. All I knew was that court was shut down and no communication with anyone, which I have very limited communication with Curtis and Deborah about any of the things they're claiming that they asked me for. They don't talk to me. They never have.
Where do you live, sir?
I live in Jackson, Michigan, at 2009 Martin Luther King Drive.
All right.
Junior Drive, Maxim.
Did you acknowledge that the house needed to be cleaned out and that there's a roof that needs to be repaired?
Okay. As far as the cleaning of the house, I shared the cost of that. It was a three-way cost. It was not singularly endured by Deborah and Curtis. We all contributed to that. As far as the roof go, there was no communication to me that they intended to do the roof. I had already indicated to Mr. Conant, because I cannot, Curtis and Deborah will not talk to me, and I've called him several times. As far as he's talking about with communication with me, there has none. They will not talk to me. And Mr. Conant is aware of that. I've talked to Curtis once or twice. And I always had to ask him, will you please have Curtis, I'm calling Curtis, please. Let me call him. They will not communicate.
Well, I have proofs here today that show that it costs $8,795.
And I did not agree to any of that. I have to agree for whatever is done to that house. I have to agree to it. And I wasn't even aware that they were doing it. All I got is a bill sent to me through the mail from Billy White Roofing. And I called and said, what? What Deborah and Curtis has purchased repair on the roof. I said, what? So I called Billy White, what's going on? He said, well, we'll be there in the morning. We're doing this right. Deborah and Curtis has contracted to have that roof. Who are you? And I told him, I said, hey, I'm the third owner of that house. He said, well, they've already paid us, so we'll be there in the morning. And I went down there and they're on the roof tearing it apart. I had no idea that was being done. Also, a couple of other items. As far as me not wanting to sell the house, I have no problem with it. I have offered indicated to Curtis that we have a buyer for the house. I had somebody offering money for the house, and he tells me, I don't want to do that. I want to see how much it's worth. I've indicated to Mr. Conant to impart to them that somebody is offering to buy the house. I don't hear anything about that.
You've got.
As far as access to the house, somebody does have access to the house with keys. And I talked to Curtis for about 5 minutes, if that long, about a week or so ago. And I asked him, have you seen the house? Yes, I've seen the house. And I went to the house a couple of times and the door was open. Was unlocked. So as far as saying they don't have access, that seems a little dubious.
So, Mr. Walker, the relief that's been requested today is that you pay your fair share of these costs.
Not the attorney fee. I don't think I should have to pay. I don't mean to interrupt you, Your Honor.
Right.
But
Let's put the attorney fee aside for the moment.
Okay.
It costs $8,795 to repair the roof. Summer taxes have been, well, let's see. Have the summer taxes been paid, Mr. Conant? Do you know?
Yes, they have.
I'm not sure. Apparently they have been. Okay.
And
yes, they have.
Who paid those?
Devin Curtis paid their portion of it.
Oh, okay. So the aside from the attorney fees, it looks like what we're talking about today. Look at this proposed judgment again.
Mm-hmm.
The proposed judgment asks that you not interfere with their possessory rights, which basically means access to them and to a realtor to come in and look at the property and give them an idea what it's worth. You said you had someone who's willing to buy it. I won't ask you who that is, but has that person indicated a purchase price that they're willing to pay?
They've not, since the roof got repaired, they aren't interested anymore.
Oh, I got you. So you don't have anybody.
I might get back to them and see what they said they was going to buy as is, and that was what we intended to do.
All right. Well, it's been
the limited communication that I had with Devin Curtis in the beginning of this process was that we will sell the house as is. That's the only thing that I agreed to do with the house with them. That's the only thing I can afford to do. And then they come with the roof repair. But if it doesn't enhance the value of the house when it is sold, but in fairness, because they are my brother and my sister, and I do love them, whether they, I would be fair with them. I would go ahead and acquiesce and give them a third of that cost for that roof.
So you're willing to have the property sold?
Oh, yes, I want to sell it. My grandson, I was hoping that we could maybe hold a little bit of time and so my grandson could keep it in the family. He was wanting to buy a house and raise his family in. But since all this skirmish has came up, he said, hey, in the last couple of weeks, hey, forget it, Grandpa. Just go ahead and try to get rid of it because you don't need all this turmoil. So you don't like it in the family, and neither do I.
You're okay then with it being sold through a realtor for the best price you can get for it?
Yeah, right now I am. But before, in Your Honor, there's some half-truths being distributed here. Mr. I forget the realtor's name. Production, he worked for production. He proposed 3 different price categories for the house. How he arose at those prices, I would think there would have to be some access to the house. The top price he proposed was in the mid-40s in that area. than 3 other lesser prices for the home. See, I have no problem with selling the house. And then the understanding that I have, and it has been imparted to me that whatever is done with the house, it has to be in agreement with all 3 of us. Not one unilaterally or 2 in conjunction. All 3 of us have to agree with what to be done. And I have no problem with that. We all agreed to sell the house. But when and to whom, that was the only contention. And not adding more costs to the property. That was our understanding in the beginning. But when they unilaterally, the 2 of them got the roof repaired. Since that has happened, well, I say, well, that's my brother and sister out,
So I understand your frustration there, sir. What I'm trying to get at is that you agree that the property does need to be sold.
Well, we intended to do that.
And if I were to provide in a judgment that the property is to be sold, listed and sold, that's something that you would be amenable to.
Oh yes, I would do that. Since my grandson, I said, he don't want nothing to do with it. And I called him, I hate to keep interrupting you. And trust me, I'm not being disrespectful. But it's frustrating when you get to have truths. I called them numerous times to try to talk to them about this, but they refused. And they said, you got to talk to our attorney. We don't attorneys representing us. Representing us. That's why I find it very objectionable for them to say I should pay for their attorney fees when they just refuse to have any communication. It was not necessary to even have an attorney involved in this. I'm sorry.
Well, you know that when a house is sold, there are expenses associated with that sale. There's fees that are incurred. That usually comes out of the proceeds of sale, and then what's left gets split equally. In this case, they have incurred expenses for the benefit of the property that they deserve to be reimbursed for at the time that it's sold. And I realize you're not in support of payment of the attorney fees, and I'll address that in a moment. But certainly there will be some attorney fees incurred in connection with the sale of the property.
Oh yeah, anything that generally goes with the sale or dealing with the property, yes, I understand that, yes.
All right, so Mr. Conant, I don't think there's a basis for me awarding the attorney fees in this action unless you can identify a statutory basis.
Well,
but
let me just have a say on behalf of Curtis and Deborah Walker. Mr. Booker Walker's got his story, and that's all he's telling this court. And it's a good story, but it's not the truth. There was never any agreement to sell this property to his grandson. We never even knew who the potential buyer was until just recently. And we don't want to just sell this property to his grandson. We want to sell it to the best offer we get. And how are we going to know what the best offer we can get is? Well, you would probably get a realtor out there to give you a good faith valuation with access to the premises. And did Mr. Booker Walker make that available to us? No. Did I call once? No, I must have called a dozen times if I called once. I sent at least 3 letters to him. No cooperation. All of a sudden in the last 30 days, I've heard more from Mr. Booker Walker than I have ever wanted to hear from him, because suddenly he's got some interest in cooperating. Before that, he was in the catbird seat. He could keep these people from selling the property.
Hello?
They could continue to pay taxes. Let me have my say, Mr. Walker. You've had your say. The truth of the matter is not what Mr. Walker is representing. The only way my clients could get access to get something done was by filing a lawsuit, which incurred expending funds for an attorney, expending funds to file it, expending funds to have him served with process. And then what did he do? He didn't do anything. He wouldn't even be online right now with the court if it hadn't been for my office making available the court's this telephone number. So he has been nothing but a drain on this property. We've had to hold on to this property for over a year, longer than we should have, to get this property sold. His conduct has been reprehensible, and he should certainly have to pay actual attorney fees in my client's estimation. Thank you.
I'm sure that's how they feel, Mr. Conant, but you know as well as any other practicing member of the bar, the court is not allowed to award attorney fees unless there's a specific statutory provision that justifies it. If you can't identify one, and I'm not aware of one, I cannot award attorney fees in this action. I can include in my judgment that any attorney fees necessitated to complete the sale of the property should be shared equally, but I can't award the attorney fees of this action. I don't have authority to do that. I can award costs, but I can't award the attorney fees. There just isn't a statutory basis for doing that. Mr. Walker is willing to cooperate in the sale. I'm comfortable signing the proposed judgment. I'll just simply delete the attorney fees. And I will add in that upon the sale of the property, that the three joint tenants be equally responsible for the costs of sale.
That will include the cost of the roof repair, Your Honor?
Yes, I'm going to leave that in. And let me make sure the math is right. The summer taxes apparently have already been paid. So that shouldn't be included in here. But the share of the...
Wasn't paid by my sister and myself. Excuse me, Your Honor.
Well, hold on, Mr. Booker Walker. I thought you said that was paid, the three of you paid that equally.
Yeah, Curtis and Deborah have, whatever their portions are of the taxes that are outstanding, that have became due, if they've paid their portion, whatever is left, that belongs to me.
Okay.
What proof does he have? He paid his
winter or something, summer taxes.
All right, I'm hearing now. I misunderstood what he said earlier. The summer taxes haven't been paid. I'm just going to say whatever taxes are outstanding need to be shared equally.
Okay, sounds good.
The only thing that I'm going to specifically impose with a dollar amount are the, just a second, is the share of the roof repair and the costs of the action, because those are recoverable. Go ahead, sir.
About the taxes, I think whatever taxes that became due at the time that Deborah and Curtis paid, like the say the winter taxes, if they paid this year, that was due most recently. If they paid this year, whatever is left on that would be the portion that I'm responsible for, and that's what I will take care of, is what I'm saying.
Okay, I understand
Rather than, in other words, if a certain amount is due, like $300, $200, or $150, that is mine. That's not, they shouldn't have to pay that. I want them to pay that, be responsible for that. I just want to be fair with them. I don't want to take advantage of that.
All right, well, give me just a moment and see if I can
I guess what I'm saying is partial payment is due, on the due taxes are up to date, and there's something left for, partials. That's mine.
All right, Mr. Conan, I will prepare a judgment. I'm not going to do that now because I've got people waiting, but I'll make sure that Mr. Booker Walker is responsible for his share of the roof repairs that's specified in the judgment, that the parties are to share equally in costs of sale, taxes that are paid at closing or before the closing. I'm not going to award the attorney fee for the cost of this action, but any attorney fees incurred in selling the property need to be shared equally. And I will award the cost of this action. There is a basis for that. I will prepare that and send it out to everyone.
Will that cover our ability to go ahead and get it listed with the realtor without
Get it cleaned out?
over that?
Yes.
Very good. Thank you so
Can we
much.
choose our own realtor, Your Honor?
There's well, let me ask if that's going to be a problem.
Really?
I thought I saw a realtor identified.
Dan Verlin from Production Realty, Your Honor, was the
Production Realty. Is that, do you have a problem with that realtor, Mr. Walker?
I don't know. It's our property, and we have a right to say who we want to handle the sale of our property. They have their right to have their opinion, and so do I. This was somebody that just was imposed on me. I didn't have any say in whether I did agree with that realtor or anything. I just want to have my rights just like I think they should have theirs.
Do you have a problem with this realtor? I realize you had a problem with how they came about it, but do you have a problem with that specific realtor now?
Precisely, no, I don't. But I would like to talk to him and see if,
What I'm trying to do is to save any of you any further dispute.
Any more grief, yeah. Okay, I'll go along with that.
All
That's
right.
fair.
I'll specify Production Realty as the listing realtor.
Okay.
Okay, and I will prepare a judgment. The judgment for the sale is something that Mr. Booker Walker is in support of. So I think I can reflect that as to that portion, that the parties consent to the property being listed and sold.
Okay.
Very good. Thank you, Your Honor. Appreciate your help.
Thank you. Thank you, Mr. Walker, and Ms. Walker. Have a good day.
Thank you.
Thank you.
All right.
Okay, and I think we're ready for KG.
Eric White's client, Bob Sales, is planning to attend via Zoom.
He's there.
Eric White is with Judge Rapley's right now.
He's in my Zoom room.
Oh, okay. Well, then he must be done.
All right, as soon as we have an audio connection with everyone, we'll go forward.
Thank you, Your Honor.
How you doing, Mohammed? Staying safe?
I'm doing well, Eric. How are you?
Hanging in there.
How are things up there?
Oh, it's all right. My son's got COVID, and hopefully he's going to be done with that. Get home from Western Michigan for Christmas.
I hope so, man. We'll keep you and your family in our prayers for sure.
Appreciate that. We're missing. Oh, there he is. Ken?
Good morning, Your Honor.
Good morning. Looks like we've got a connection with everyone except Stacy Mohammed.
Is that the court reporter?
I have no idea who it is. It's just somebody that's trying to log in. I assumed it was somebody associated with this file. I don't have anything else scheduled until 10.
No, there's nobody else on the file, Your Honor.
Okay, I will simply remove that person then. And none of you are expecting anyone else to participate today.
No, my client's in, Mr. Sales is in, and just the two of us.
All right. I won't, well, let me find out. Looks like we're very close to a connection. Well, maybe not. All right, I'm just going to let that spin. I don't know who it is. When it does finally connect, I'll ask. But okay, so counsel, if you could each state your appearances, please.
Good morning, Your Honor. Mohammed Nimi on behalf of the plaintiff, Martin Kaji.
Mohammed Nehme, Nehme.
That's right.
And Eric White and Kenneth Beams.
Kenneth Beams for LEGC LLC.
Eric White on behalf of Bob Sales and Jackson Property Partners.
And Mr. Bob Sales is also present. Okay, I think we've got two motions up today, if I remember correctly. We've got a motion for rehearing, reconsideration, and I can't remember.
The other one, Your Honor, is
A motion for summary, yes.
yeah, it's a continuation of my initial motion for summary, and it's only on the point of whether or not Mr. Kaji had the proper funds to pay at closing. That was the only issue that was remaining from the last court's order.
All right, well, let's address the motion for reconsideration first.
Okay,
That
Your
would be
Honor.
yours, Mr. James?
That is my motion, Your Honor. And I want to make sure you understand, I don't think I've ever filed a motion for reconsideration in my 20-year career. And the reason
I'm
why
not offended.
it's very rare that I filed motions for set aside judgments or orders before, but a motion for reconsideration for me is very rare because I know the standard is very, very limited in terms of what can be, the standard is pretty hard or high, but I think this one fits. Because of the numerous factual errors contained in the opinion and order. And I think just on page, as I read it again this morning, and on page 3 and 4, or 4 and 5, there literally every fact contained in the bottom paragraph on page 4 and started in page 5 was incorrect. And I think those facts are what the court relied upon.
Well, hold on a minute. I want to have that in front of me. Okay, so
the bottom of
page 4.
Maybe not literally everyone, but almost all of them were just incorrect. Based on, and if you look at the motions and the various exhibits and affidavits and the testimony from the depositions, these are just not accurate, and I don't know why. And I think the court.
I want you to point out each one that's inaccurate.
The sales ignored both plaintiff and the title company's numerous attempts to schedule a closing before January 11th. Is not accurate. That's just, we have an affidavit from Mr. Sales. We also have documents that were attached to the briefs that show that was not true.
I want to make sure we're clear on this. We had representations made that there were communications regarding this particular sale. And it was quite obvious that the emails that were being addressed had nothing to do with this sale because they included a realtor who was not involved in this sale.
That's just not correct, Your Honor. Well, let's get to that point. That's the first thing that I believe is not true. Mr.
Well,
Sales.
show me by affidavit, by document, how it's not true.
There is documents attached to Mr. White's response and my response. Mr. Sales reached out to the title company on January the 9th. He emailed Denise Ellison and didn't copy it. And the subject of the email is Ricky and Joey. Ricky is Ricky Manjo, who is the individual that initially signed the purchase agreement that was assigned to the plaintiff, and Joey was the plaintiff's attorney before Mr. Nahimi got involved. He was the one that was sending letters to Bob Sales and the title company and emails and reaching out. He was the one that drafted.
It's clear that there are some of the same parties involved in the first sale, the first purchase agreement, and those in the second. There would be, because it's the same seller. The problem is we've got an affidavit from the owner of the title company saying that the owner of the property, the seller, would not respond to any of the title company's attempts to confirm the closing.
But again, Your Honor, that's
and the only documentary evidence that was provided to the court were emails that included a realtor who was not involved in that transaction.
There were two emails. One email that was sent on the 9th from Bob to Denise, in which there's no mention of Alex Perlos at all. And the email is titled Ricky and Joey. Those are the parties to the purchase agreement with the plaintiff. And no one's copied on that email. There's no mention of Alex Perlos at all. And then there's a subsequent email, which Alex Perlos isn't copied on. But Alex was not, I mean, part of your opinion in order mentions that Alex Perlos is a real estate agent for LEGC. And that's one of the facts that I pointed out in your opinion in order. That's not correct. He was never, he was the real estate broker for the seller only. And his affidavit, which was submitted to the court, states that he was not LEGC's broker.
Regardless of whose broker he was, the facts presented to the court were that he was not involved in the first purchase agreement. He was only involved in the second purchase agreement. You're saying that's not true? You're saying he was involved in that first sale, and you have facts that can establish that.
No facts were submitted in any of the briefs which show that he was involved with the first sale, because, however, he was involved. He was involved. I mean, this was not part of the record in any of the briefs that were submitted. And it was never even brought up until post-hearing when there was a brief submitted that called, which Mr. White was accused of lying to the court. He was not LEGC's real estate agent. The affidavit, Mr. Perlos's affidavit says so. And your opinion in order relies on the fact that this specifically says that he's a real estate agent for LEGC. That was not correct. He was Jackson Property Partners broker, real estate agent.
But if he was not involved in the first sale, it's a distinction without a difference, is it not?
I disagree. I think the fact of the matter is he was involved with the sale of the property. The house, I mean, He also
He
happens to
was
be
involved with the sale of the property, the attempted sale of the property to LEGC. He was not involved with the attempted sale of the property to Martin Cagey.
But the timing of that email, which Alex is copied on or referred to, it came after Bob Sales reached out to the title company expressing a desire to close with the plaintiff. And then a day later, he sends an email back to him with documents that Alex is copied on. I don't see how that says that was the second sale. There's no evidence that says that was for the second sale. That was a leap in logic on the court's part that was for the second sale. There's no evidence that says that was for the second sale. Just because he was the broker involved with the sale with LEGC doesn't mean that email necessarily was for the second sale. There's no testimony, no documents that say that. And
Your Honor, I can easily address this one already.
Let's do that. Go ahead.
Well, on the issue of Alex Perlos, first of all, you're right. It's a distinction without a difference as to who hired Alex Perlos. Even though Mr. Sales did testify in his deposition that he didn't even know who Alex Perlos was until Alex Perlos approached him with an offer from LEGC. That's the very first time he ever met Alex Perlos. There. So you're right. Alex Perlos was never involved in the transaction with Mr. Kaji. In fact, when the entitled company was trying to request confirmation for the closing, and they were trying to get a payoff statement, Mr. Sales never once, there's not an email or a shred of documentary evidence that shows he ever once confirmed the closing. There's not a shred of documentary evidence that ever shows he provided them with a payoff statement. On the day of closing, he reached out, he emailed the title company and he told them, I guess you could try to reach out to the mortgage company to get a payoff statement. And if you can't get it, oh, well, we tried. Well, the reality is he never tried. He didn't do anything. After the closing date had passed with Mr. Kaji, the very next day, Your Honor, Mr. Sales emailed the title company with a payoff statement that he says was requested from Alex Perlos. Then that following Monday, the title company sent out an email to Mr. Sales confirming the closing date that was scheduled by Mr. Perlos and lists LEGC as the buyer in that transaction. That's attached as my Exhibit P. There's no dispute at all here. Mr. Sales was trying to avoid closing with my client. He wanted to close with LEGC. When it came to scheduling a closing with LEGC, he was more than willing to cooperate with the title company. He was more than willing to give them the documents they needed to prepare a closing statement. But when it came to Mr. Kaji, he didn't even respond at all. Not one email shows that he confirmed closing. Not one email shows that he provided them with a payoff statement. The court,
with respect to the payoff statement, that was why Mr. Sales reached out to the title company on the 9th, specifically authorizing Denise Ellison to go obtain the payoff statement. That was the whole purpose of that email, so that she can finish up the closing paperwork.
Your Honor,
that was the email that he sent to Denise. And Bob couldn't draft a payoff statement on his own. He's not the lender. Yeah, that has to come from the bank.
Your Honor, the title company told Mr. Sales we cannot request a payoff statement because we don't have your written authorization and we don't have an account number. And do you know how Mr. Sales responded? He said, "Oh, I see."
That's not true. That's why he sent those documents the next day with the mortgage statements and the mortgage documents. That was the purpose of sending that email to Denise.
Your Honor, he sent it the next day because Alex Perlos told him to send it to him in order to close the LEGC. That's why the following Monday, just 4 days later, the title company responded back to Mr. Sales saying, now we are confirming the closing that was scheduled by Mr. Perlos. And list LEGC literally in the body of the email as a buyer.
There was also closing paperwork prepared for the plaintiff.
No, there wasn't.
With a specific purchase price to wire to the title company. That never happened. This is the whole gist of this lawsuit, is why the plaintiff didn't pay.
Mr. Perlos, Mr. Sales would not respond. So they tried to estimate what the closing costs would be. Once again, there is nothing in the record that shows Mr. Sales confirmed he would be appeared for closing, and there's nothing in the record that shows Mr. Sales provided the documents that were necessary to provide a closing statement to close. And if you want to address Mr. Sales' affidavit, we can do that, because it literally lends no support to Mr. Beams's argument, even though he can't argue anything about this affidavit because it wasn't attached in his MSD or his response to our MSD. So he can't bring it up as a new argument for the first time on a motion for reconsideration.
Your Honor, that's one of the facts in my brief that is incorrect, that Mr. Sales' affidavit was attached to Eric White's response.
Yeah, Eric White, you didn't argue it.
It's part of the record.
You didn't argue it.
Yes, I did.
You did not argue it.
It doesn't matter. It's part of the record.
All right.
And the court made a factual finding that was incorrect.
Counsel, address your comments to the court, not to each other.
Sorry, Your Honor.
I apologize. But I can address the affidavit if you'd like, Your Honor.
Go ahead.
Mr. Sales' affidavit does not oppose or contradict any statement that was made in Mr. Ron Ellison's affidavit. Mr. Ron Ellison is the employee of the title company, and he testified that plaintiff was trying to close, but that the seller, Jackson Property Partners, did not respond to the title company's attempt to confirm closing. Nowhere in Mr. Sales' affidavit does it say that he did, in fact, confirm closing. Certainly, there's no emails to support that either. Sales' affidavit was drafted in a way to be intentionally vague. So, for example, it says that on January 10th, he provided information to the title company so we could close. Okay. However, as we've seen from the evidence, the only email that was sent from Mr. Sales on January 10th was a payoff statement that was requested by Alex Perlos. That was what allowed the title company to confirm the closing with Jackson, with the LAGC 3 days later. So his affidavit is nothing. It's drafted in an ambiguous way that could put either party, if you're depending on which lens you're looking through. But the reality is, the only information he ever sent to the title company was to go close the LAGC, and there's nothing that could prove otherwise.
So, whatever documents, affidavits, etc., that exist on this issue are presently before the court, that are part of the record before the court. Is that correct?
Yes, Your Honor.
What I'm going to do, I want to hear the next argument. I will go back and look at these things. If there are some factual errors, in my opinion, I will correct them. If I think those factual errors would result in a different decision, I will issue a different decision. So I don't need to hear any more argument on that. I want to hear the other argument as to ability to close.
Thank you, and I'll start with that. So the court held in its October 2nd order that the plaintiff only showed the ability to tender $300,000. That was evidenced by the affidavit from the financier. And so the court believed that it fell short of the $545,000 or so required to close. When the court provided us the opportunity to supplement our motion, we took advantage of that. As the court knows, the parties were supposed to close before January 11th. So I attached Mr. Kaji's bank statements from January 1st and from January 31st to show how much money he had in his bank accounts for those months, for that month. In one bank account with Level 1 Bank, he had $164,000. At the end of the month, he had $160,000 in that same bank account. So let's just put it at 160. And then we have in another bank account, and I attached the bank records here, $246,000, both in the beginning and at the end of the month. That totals about $406,000 that he had in cash. Remember, the purchase price was $545,000, close to that. And he had the pledge of $300,000 from the financier, Jason Brico, who attached an affidavit. Mr. Brico was named in Mr. Kaji's deposition as the financier. He provided an affidavit, and he was listed as a witness on the witness list. The defendants chose not to depose him. They chose not to question his affidavit. They chose not to question anything regarding his ability to finance the $300,000, of which you only had to really give him about a little over 100,000. So I think that there's undisputed evidence that Mr. Kaji had enough money to close on the closing date.
Mr. Beams?
I mean, my response to their argument is essentially the same response I had in the summary disposition brief, which is the very inconsistent statements made by the plaintiff with respect to his ability to purchase the property. You know, in written discovery, it was one thing. It was someone's going to loan him $150,000. They didn't know, a local financier guide, unidentified. And then in deposition, it was completely different answer when I asked him about who was gonna loan the money, and he didn't know he acted like didn't really know who he was, didn't know where he lived, didn't really have a deal with him. It was just sort of a handshake deal that, you know, he didn't know how he was gonna get paid back. Didn't know what kind of interest was gonna be paid on it. It's just a very vague sort of situation. There was no loan agreement. There was nothing between the two. It's just, oh, he's going to loan me $300,000 or whatever it was that he testified to in the deposition. And I think that just very, very, and then we get the summary disposition, and out comes this guy is going to loan him $300,000 pursuant to affidavit. Well, it's very inconsistent with what the plaintiff testified to on 2 occasions. One in written discovery and one under oath. And I just think that's something that the trier of fact should be able to evaluate the credibility of these witnesses.
Your Honor, if I may, I would like for counsel to demonstrate the inconsistencies between the written discovery and the testimony in the deposition. Because what was said in both of them is that Mr. Brico would be financing, at the time, yeah, he was financing $150,000. His affidavit says he was willing to give him up to $300,000. There's no inconsistency there. Mr. Beams, for some reason, keeps highlighting on the fact that Mr. Kaji didn't know Jason Brico's home address, as if that's the be all end all, and that means he's lying about something. No, he didn't know his address. He did not know his home address. Doesn't mean that he wasn't going to finance him. There's nothing in that record right now to contradict the affidavit by Mr. Brico that he was willing to give Mr. Kaji up to $300,000.
So Mr. Beams, what are the specific inconsistencies that you're identifying?
In the responses to the written discovery request, which I attached to the brief as Exhibit A, in the response to interrogatory number 9, Mr. KG said he had roughly $405,000 in cash and obtained a line of credit from a financier for $145,000 to cover the total purchase price. Not that seems that seems very unfathomable that Mr. KG would literally spend every penny of his savings to purchase a building and be left completely broke at that point. I think that strikes me as being very not credible, not believable. And when I got him under oath, he testified differently.
Where?
And then the affidavit that's submitted by Mr. Brico says $300,000.
Okay, hold on.
About not 145.
You said under oath he testified differently. Identify what you're referring to.
Give me 1 minute, Your Honor. Well, okay, so he again testified that he was going to loan him the difference. Again, and again, the terms of the deal was very vague. There was nothing in writing. There was no commitment. There was just a handshake, word of mouth deal, is what he testified to. And again, it was literally, he's going to spend every penny to purchase this building and be left broke, and knowing the build out that had to be done, would have to be done for this building to convert it from the current use to a dispensary for medical marijuana. It just, to me, lacks credibility. Again, there's a lot going on here. I think their testimony is very, very, it just lacks credibility. But so I take that back. His deposition testimony is not necessarily inconsistent with the written discovery. What lacks credibility is this further testimony regarding the lack of any solid agreement with this lender of his. The fact that they had nothing in writing discussing how it was going to be repaid or anything seems a little unusual to me.
Mr. White, do you wish to weigh in with respect to either issue?
Well, I guess I look at, if this was like a line of credit from a bank, this appears to be some type of friend or business partner that simply does an affidavit that says, I'm going to loan him the money. That's a different story than I've got a bank letter of credit or a letter of intent, or I've been pre-approved. There's not even a writing other than an affidavit that this person has the ability to do it or is going to. Usually in a transaction with this kind of fundage, you'd see documents that were prepared by counsel and that outline those terms. This appears to be a rather convenient way to say that they have the funding, and that's a credibility issue that the trier of fact should be able to determine, make the determination whether they truly had that ability based on those lack of things like writings and things other than an affidavit. Thank you.
Your Honor, if I may.
Go ahead.
His ability to finance his portion of the purchase price, that should have been challenged during discovery. As I showed you in my motion, we listed him on the witness list. We mentioned him in depositions. We mentioned him in our written responses to discovery. They had the opportunity to challenge that. They had the opportunity to request and subpoena his bank records to show that he had the money. They didn't do any of that. We have an affidavit saying he had the money. It's their obligation and it's their burden to show that he didn't.
Your Honor, I would have loved to have challenged that testimony. That's why I asked him.
Hold on.
That's why I asked him where he lived, and he did. The borrower didn't know where he lived. Sorry,
Mr. Nemey's arguing. Wait your turn.
Sorry, Your Honor.
They had an opportunity to explore that during discovery. They failed to do so. So now the only evidence the only documents that's in evidence is his affidavit swearing under oath that he had up to $300,000 to give Mr. Kaji. They have nothing to dispute that.
All right, gentlemen, I am going to take a hard look at my opinion. If I believe that corrections need to be made, I will make them. If I believe that those corrections result in a different decision, I will make a different decision. And I will also at the same time consider the issue of the ability to close as to whether or not there's a question of fact on that issue.
May I rebut what Mr. Nemey said, or are we all set? I was trying to make the point there. That's why I asked.
I don't want to cut you off. If you want to say more, go ahead.
Well, I mean, I asked him in deposition. That's why I asked him specifically in deposition when he said Mr. Brico is his financer. That's why I asked him, do you know where he lives? And the answer I got, well, somewhere in Bloomfield Hill or West Bloomfield. He didn't know where he lives. And this is a guy who's loaned him $300,000 on a handshake. I would expect you know where this person lives. But I would have loved to have taken this person's deposition or subpoena his bank records. But I didn't. I've never once was told in discovery. I was told late in the game who this person actually is. And that's all I know is this person's name. That's it. They didn't disclose his address.
Did you ask for his business address?
No.
Does he have a business? I mean, I asked him. Never mind. We're all.
All right. Well, I'll take a fresh look at all of this, gentlemen, and we'll issue a supplemental opinion. Thank you.
Thank you very much.
Judge, you want me to get my client? She's here on the other case we have.
Sure.
Oh, that's fine.
Thank you, Your Honor.
Okay, this is Ayers versus Silvius. Mr. White for the plaintiff, Mr. Liljuri for the defendant. And it appears that both parties are also present in their attorney's offices.
Good morning, Your Honor.
Okay.
Good morning, Eric.
Good morning. All right, Mr. White.
Thank you, Your Honor. I know the court's read my motion. It's rather bizarre, and it unfortunately I need to update the court. It gets worse. The defendant's friend has she did make a false report to CPS. CPS came to my client's home. They did a quick investigation and found that it was a false report. This young lady also contacted my client's employer and made a complaint that I have copies of, indicating that she had been racially discriminated against in the sale of a piece of property. Interestingly enough, this Jasmine McJames is a white person, so it appears as though she's wreaking havoc on this family, and we need to protect the child from what's going on over there.
Okay, Mr. Liljuri, I don't know if you filed any kind of
No,
written
Your Honor.
response.
No,
I'm not surprised because I know it was short notice, but
I
don't know the defendant's position on any of these allegations.
Let me, it won't be long, what I have to say, Your Honor. This all started, my client told this woman, Jasmine, that's her first name, that she needed to move out. In response to that, she retaliated and sent these messages that my client drinks and drives with the child in the car. That's not true. One of the things that is true, because I want to be honest with the court, is he did say to her, they put in their motion, Mitchell did say to Jasmine, you know, why don't you just start a shotgun? He admits to saying that the child was not there. This all started because he said she had to move out of his house. She is in the process of moving, is going to be completely out by tomorrow. Correct, Mitchell?
Correct.
And then so she sends these things like trying to make Mitchell look bad. Then she sends these disgusting text messages to Miss Ayers, just disgusting messages saying, I didn't mean that. I was mad, and says all these horrible things to her. Threatens to call CPS. My client does not have any concern about Miss Ayers' husband, so he didn't want that to happen. My suggestion, if I could have any, is that I think Miss Ayers needs to get a PPO against this woman because what she's doing is wreaking havoc, not just in Mr. Silvius's life, but also in Miss Ayers' life. And I'm sorry that happened. Obviously, this Jasmine is not a healthy person, and that's why Mitch is terminating that relationship and told her to move out. And as a result of that, all this happened, Your Honor. So I don't dispute anything Mr. White is saying. I'm just giving the court the context. And what I'm asking the court is the parenting time be restored, that I'm okay with the condition that this woman never be around the child. You know, she's gonna Like I said, she'll be out of the house tomorrow. She signed a lease in Lansing. Anything I'm saying incorrect, Mitch? Okay. So I know this woman is an unhealthy person.
It would appear that way from
Yes.
everything that I read.
It's disgusting, you know?
The problem, Your Honor, is just as of yesterday, Jasmine, who's from Ingham County and supposedly is moving up there, was on Facebook in a group looking for a daycare in Napoleon. This was just yesterday. My client remains strongly concerned that this breakup between Jasmine and the defendants is not going to actually happen, and that we're going to be back in the same boat here shortly. As you could tell from the previous motion that my client had filed that has us waiting for an evidentiary hearing, this is unfortunately part of a continuing pattern. And I don't know if it's how I could do this, but perhaps the court should hear the defendants being audio taped by Jasmine. It's kind of disturbing. I'm just not sure how you can protect this child when it doesn't appear that Jasmine realizes that this relationship's over.
Well, my suggestion is, and I would consent to it, is that my client would, is that a condition of restoring parenting time is that this woman be nowhere near this child. And my client has to get a PPO against her for that to happen. I'm in a strange circumstance, Your Honor, where I agree with all their concerns. But I think it's remedied by she's moving out and that she shouldn't be anywhere around this child. And Miss Ayers can do what she wants, but she may want to consider getting a PPO. And that's something eventually my client might have to consider.
So if I were to restore parenting time with an absolute condition that there be zero contact and zero exposure of the child to this woman, why doesn't that at least solve this immediate problem, Mr. White?
It certainly does. That certainly does. But it's funny. I love social media. 25 minutes ago, Jasmine is posting her status that now she's in a complicated relationship. I guess my client can certainly live with that. And we're going to have an evidentiary hearing coming up. But I think we need a mechanism in which where we can come back before this court if it turns out that Jasmine is still in the defendant's life. I'm not sure exactly how we could craft something, but we've got to make sure that if she comes back in his life, we've got to have some protection for this young girl.
It looks to me that the defendant has complete control over that.
Yes.
He cannot allow her back. He cannot allow this child to be exposed to that woman ever again, ever. And if that happens, if my order is violated, I will be left with sincere reservations whether I can ever trust Mr. Silvius again to protect his child.
Your Honor,
the consequence would be very, very serious. This woman is unstable. I don't want her around this child ever. If you need to get a PPO, get one. But she's got to be gone, and there cannot be any exposure. So I'm going to restore the parenting time with that absolute condition that there be no exposure and no contact whatsoever with between the child and Jasmine, whatever her last name is.
McJames.
Yeah.
McJames.
I'll prepare an order, Your Honor, and I know my client feels better hearing you clarify that this person's got to be out of the child's life for sure. So we appreciate that. I'll get an order prepared and appreciate the court's time.
Thank you, Your Honor. Thank you, Mr. White.
Thanks,
you,
Nick.
and we'll
have a good day. Thank you.
Have a good day.